Well, a very warm welcome indeed to this LMAA arbitration moot. My name is Sarah Kay. I'm the host for the event, but the real players are here, and the tribunal, who, as you can see, are not here yet, but they will be coming in, and I will introduce them all shortly. This moot is designed to give you a taste of what a real LMAA arbitration might look like. The subject matter of the dispute is very close to our collective hearts, and that is whether the ship owners were entitled to treat the charterers as having repudiated by renunciation the charter party. In other words, did the charterers unambiguously tell the owners they could not or will not perform their future obligation to pay hire? If they did, this renunciation of the charterer was one which entitled the owners to treat the contract as at an end. Am I getting it right with the microphone? Okay, thank you. You will see that we are going to take this as a preliminary issue. Before we start, a few housekeeping points. We have just under 100 people in the room and an astonishing 300 plus online. I shall do my very best to make everybody feel as though they're in the room. So I apologize in advance to those in the room who think I'm addressing the camera and those online who think I'm addressing the people in the room. You should have received a pack of documents. These comprise an itinerary for the next 2 hours, outline facts, 2 witness statements, skeleton arguments from both sides, key clauses from the charter party, and summaries of 2 cases. Arbitrations usually begin in the morning, but this arbitration demonstrates the flexibility of LMAA arbitrations because we're starting at 4 p.m. And we have done so to accommodate the parties' speed. On this occasion, too, we have witnesses giving evidence in person, but LMAA arbitrations have for many years offered parties the opportunity for witnesses to give evidence virtually, and this was long before COVID made it widespread. We have some audience participation. We are going to ask the audience to vote twice on who they think should succeed. The first vote will take place immediately after my introduction and before the hearing begins. And the second vote will take place after you've heard the evidence, after you've heard closing submissions, but before the tribunal renders its award. There will be time for questions, but only after the proceedings have closed and the award rendered. To assist in advance of the first audience vote, I shall briefly outline the facts. The charterers, Duxton, had a history of paying hire late. The charterers found themselves in financial difficulties, and as the vessel was on a ballast voyage with a view to discharging in Pakistan, on Monday, the 3rd of February, Miss Bridge of the charterers telephoned Mr. Ford of the owners and asked for a 40% discount on hire. She followed that up with an email the next day, which was Tuesday, the 4th of February. And the admissibility of that email is the subject of an application which will take place at the beginning of the case. A second phone call took place between the same 2 witnesses the following day, which was Wednesday, the 5th of February. It is this second phone call that is the particular focus of this dispute. And that is because in it, Mr. Ford said that he could not assist with the discount, but it is disputed as to what Miss Bridge said in response. Mr. Ford says that she said she did not know whether she would be able to carry on performing. You might say a classic case of who said what on the phone, because it is Miss Bridge's case that she said she did not know whether they would be able to continue carrying on performing. The next day, which was Thursday, the 6th of February, the next hire instalment was paid in full. But later that same day, the owners terminated the charter party, purporting to accept the charterer's renunciation of the charter party. One of the charter party terms is an anti-technicality clause, a BIMCO clause, that obliged the owners to comply with various requirements as to giving notice within certain time limits. When I read the facts, I was struck by how context plays a role on how people react. And as to context, I came across a judgment of Lord Denning in which he said this: "When I was young, a sandwich man wearing a top hat used to parade outside the courts with his boards back and front, proclaiming, 'Arbitrate, don't litigate.'" Pausing there, I thought to myself, what a fantastic advert for arbitration. But in fact, if I had stopped there, I would be taking that statement out of context, because the quote continues, "It was very good advice so long as the arbitrations were conducted speedily, as many still are in the City of London. But it is not so good when arbitrations drag on forever." That is the end of the quote. And I only mention it in case it is thought that the context has a bearing on the outcome of this dispute. And with that, let us have our first vote. I think for people in the room, it's a matter of raising your hand. And then for people online, I believe you can obviously select a yes or no alongside the question. So let me put the question. Did the charterers unambiguously demonstrate to the owners that they could not or will not perform their future obligations to pay hire in accordance with the terms of the Charter Party? Those online can vote now. And those in the room, those who want to say, yes, the charterers did and unambiguously demonstrate that they could not and will not perform, please raise your hand. Those who are going to, I should just say to those online, nobody in the room has put up their hand, but I don't know why. There could be more than one explanation for that. I'm not going to assume 100% of you all share the view that the owners jumped the gun. So what I suggest we do is we come back to this for the second vote and see if anyone's got a view or has changed their mind. I don't know, are the results available for what's gone on online? I don't know. I can't see anything, but we'll come back to it, no problem. I'm now going to introduce the dream team. That involves asking the tribunal to come in and join us. John, please. So I said I'm going to introduce the dream team. That expression applies to everybody here. Let me first start with the tribunal. This is a three-person tribunal, as you can see, and it represents the usual position of where one party appoints an arbitrator, the other party appoints its arbitrator in response, and the two arbitrators so chosen appoint a third. Regardless of who was appointed by whom, the tribunal members are entirely impartial. We're going to start with Daniela Horton, who was appointed by the owners. She needs no introduction other than to say she is one of the stars of the LMAA. Ben Goss, who will raise his hand, was appointed by the charterers and has very successfully transited from a shipbroker of 22 years to full member of the LMAA. Playing as chair is John Elvey, our esteemed president of the LMAA and doyen of London arbitrators. We are particularly grateful to have a first-class team of counsel, all from 20 Essex, who are all specialists in this kind of work and in setting the gold standard. They are, as it were, playing themselves. In the red corner for the owners is Julian Kenny KC. Raise your hand. Alex Demetriades and Lucas Sweeten. In the blue corner for the charterers is Daniel Bovensipian and Alex Yin. And finally, our witnesses, Jeffrey Bloom, who plays Mr. Ford for the owners, a role for which he is perfectly suited, given his 52 years in chartering, which includes many years working for ship owners and operators. And Sarah Gillingham-Orkner, who plays Miss Bridge, and who has also made the successful leap from a range of commercial roles, including working for time charterers and a P&I club, to being a full member of the LMAA. People in the room will appreciate that on this occasion, we have witnesses giving evidence in person. But LMAA arbitrations have for many years offered parties the opportunity for witnesses to give evidence virtually. And this was long before COVID made it more widespread. I like to think that we, the LMAA, are pioneers in that department. That's it from me for now. The players are champing at the bit, so I'm going to hand over to our chair of the tribunal to officially start the proceedings.
Thank you very much. Good afternoon, everybody. Welcome to the IDRC. It's Monday, the 15th of September, and we are here for the hearing of a preliminary issue in the reference between Pintail Navigation Corporation, who I'll call the owners, and Duxton Marine Pte Limited, who I'll call the charterers. Disputes arising from a charter party of the vessel Pintail made between them. Now, we have a transcriber, so the session today will be transcribed and available to the parties afterwards. And I should say at the beginning that the tribunal has been asked to give its ruling or rulings immediately, ex tempore, which means that we won't have the opportunity to prepare them in writing first, but our comments will be transcribed and will be signed later as a written award for the parties. We're here for the preliminary issue of whether the charterers repudiated the charter party, and we also have an application by the charterers to exclude a document from the evidence on the basis that it is privileged. We have agreed with the parties that we'll have the openings first and then the application by the charterers, followed by witness evidence. So we'll start with the openings. Mr. Kenny.
Good afternoon. Members of the tribunal, you will of course have seen our skeleton arguments, and you know therefore that I'm here representing the claimant owners, and with me Mr. Demetriades and Mr. Switten, and of course for the charterers, Mr. Bovensiepen and Mr. Yen. You know and you understand that the claimant's case is that Miss Bridge told Mr. Ford in a pair of communications, one on the 4th of February and the second on the 5th of February, that Duxton simply could not perform its obligations under this charter. She had good reasons for saying what she said when she said it. She needed to renegotiate this charter before the voyage that the ship was about to start began. She needed to settle the position one way or another, and we say that she did it by making absolutely clear to Mr. Ford that Duxton was unable to perform its obligations. We invite you to find that that was what she said and communicated, and to find that as a matter of fact. The law, as it applies to this question, is clear and not in dispute. As a matter of law, if a party makes a categorical or unambiguous statement that it will not be able to perform its obligations under a contract, That is a renunciation, what one used to call an anticipatory breach, and the other party is entitled to terminate. As to the facts, again, a large amount of what we have to consider today is common ground. It is common ground, indeed it's Miss Bridges' own evidence, that in early February of this year, the charterers were under a great deal of pressure, financial pressure. It's common ground that, prompted by that pressure, on 3rd February, she telephoned Mr. Ford and asked him for a 40% discount on the hire that Duxton had agreed to pay. It's common ground that the next day she sent an email, and of course that email is the subject of an application you're about to hear. And finally, it's common ground that there was a telephone call the following day, 5th February, in which what's undisputed is the parties yet again discussed in precisely what terms you will have to find whether Duxton were able to perform their contract. Against that background and against all of that common ground, there are two critical questions which you have to consider. First of all, on the 5th of February, what exactly did Miss Bridge say? What words did she use? What were the terms in which she described her company's position? And secondly, bearing in mind the words that she used, and if it's admissible, the words of the email of the 4th of February, would a reasonable person in these owners' position have concluded that the charterers were categorically telling them that they were unable to perform? That's all we'll say in opening. Obviously, Mr. Bovensiepen will address you briefly in opening, and then I propose that we deal with the application to exclude.
Thank you very much. Any questions? Mr. Bovensiepen.
Thank you, sir. I don't disagree with my learned friend's relatively balanced summary of the facts, but I just wish to make a few further points that we invite the tribunal to keep particularly in mind, or which should be emphasised. Firstly, the test for enunciation has a deliberately very high threshold in circumstances where it's a doctrine with draconian consequences, which applies where termination is not justified by a past breach and only by what has been stated about future intention or willingness to perform. And in that regard, we do not understand any of the points emphasised at paragraphs 3 and 4 of our skeleton about the nature and the stringency of the test to be in dispute. The heavy burden of proof in this regard is squarely on the owners. And I agree with Mr. Kenny that having heard the witness evidence, what you will need to come back to carefully consider in closing is A, whether owners have been able to clearly and specifically identify what statement or statements of Miss Bridge during the 5th of February phone call were made, which they rely on. B, whether Miss Bridge in fact made such specific statements during that call. And C, if so, whether such statements are sufficient to surmount the exacting threshold for enunciation, having regard to what would be conveyed to a reasonable person in the position of the owners. And you will need to come back to consider that in the light of the motives of the witnesses and the inherent probabilities after hearing their evidence. For now, I will say no more than that owners' position, charter's position is that owner's case is really a product of wishful thinking. And that's all I intended to say at this stage.
Thank you very much. Do you have any questions? Any questions at this point? Thank you very much, both of you. We have no questions on the tribunal at this point. Now, I think it's been agreed by the parties that we'll move to the application by the charterers to exclude a document. Let me say for the record that in reaching a decision later this afternoon on the preliminary issue of whether the charterers were in repudiation, the tribunal will want to consider all the evidence in front of it, as well as the submissions and the oral testimony from the witnesses. The question now is whether that evidence should include or not include an email. of the 4th of February. The charterers say we should exclude it on the grounds that it's privileged. The owners say that we should include it on the grounds that it is not privileged. So we're going to take that application now so we can clear the way for knowing what the evidence is. This is the respondent's application. So Mr. Yen, if you would like to put the application to the tribunal, then I think Mr. Dimitriades, you're going to respond, and then if necessary, you'll have the right of reply. So the floor is yours.
I'm very grateful, Mr. Chairman. Charterists apply and submit that Ms. Bridges' email to Mr. Ford of the 4th of February 2025 is cloaked by without prejudice privilege and as such is inadmissible. I propose, please, to start with the applicable legal principles before then turning to the substance of that email. If we could please turn to page 11 of the packet. Thank you. I'm looking, please, at the case of Mornington 2000 and Secretary of State for Health, which both parties have agreed is a correct summary of the law as concerns the doctrine of without prejudice privilege. Now, I won't read the quotation from paragraph 45 of the judgment in full, but I wish to draw the tribunal's attention, please, to two particular points. The first is that subparagraph A at the bottom of this page, and it is this: the without prejudice privilege rule is a rule governing the admissibility of evidence and is founded in the public policy of encouraging litigants to settle their differences rather than litigate from start to finish. So at the heart of the doctrine is an element of public policy. The second point is to be found over the page, at page 12, please, and this at subparagraph B. The without prejudice rule therefore applies to exclude all negotiations genuinely aimed at settlement, whether orally or in writing. So bearing these agreed principles in mind, let's please now look at the relevant email, and that's at page 9 of the packet. Now, to be clear, at this stage, the tribunal is asked only to consider this email de bene esse, or in other words, for what it's worth, in order to formally determine its admissibility. We're not saying now that just because we're looking at this, it should be formally admitted.
Mr. Yen, for those who may not have the email, would you just read the contents into the record?
Of course, I'm grateful, Mr. Chairman. It is an email from Ms. Bridge to Mr. Ford of the 4th of February 2025. It's headed "Without Prejudice," and it begins, "Dear Doug, thanks for your time yesterday. As I explained, unfortunately, we find ourselves in serious financial difficulties. And as things stand, we are just not able to pay higher at the charter rate. I hope we can arrive at a commercial solution, because we both know that the consequences will not be pretty if we have to default. Best, Maria Bridge, Bulk Operations Manager, Duxton Marine Private Limited." So looking at the email, you can see why owners are saying against us that this email is helpful for their case, and therefore they want it admitted. But it is also precisely why we say it should not be admitted, because it's privileged. And in this regard, there are 3 points I hope to draw to the tribunal's attention. The first is that it's headed in bold at the very top, "Without prejudice." It contains those two precise words. So there can be no doubt that it was charterers' intention that this email should attract that privilege. And the second point is the context of this email. The first sentence reads, "Thanks for your time yesterday." So Ms. Bridge is harking back to a conversation that she had with Mr. Ford the previous day, on the 3rd of February. For this, let's please turn to Mr. Ford's own evidence at page 6 of the packet. And for everyone's benefit, Mr. Chairman, I'm referring to paragraph 5, where Mr. Ford describes the telephone conversation on the 3rd of February, where Ms. Bridge asked for a 40% discount on the higher rate. Mr. Ford says, "I said I was pretty sure that the owners could not agree to that, but we would confer internally and I would get back to her." So turning back to the email at page 9, we can see it is owner's own evidence that charterers had asked for a reduction in the hire rate. Mr. Ford had said, "I'm pretty sure the owners can't agree." So the point here, members of the tribunal, is that already on the previous day, there was a dispute that had arisen between the parties. Charterers wanted a reduction, and owners appear not to be very keen about the prospect. And what do charterers say about this dispute? At the final sentence of that email, they say, "I hope we can arrive at a commercial solution." These, we say, are words of good faith. These are words of negotiation, and we say this is the glue that holds everything together. There was already a dispute in contemplation, and here Ms. Bridge is saying very plainly to Mr. Ford, "I hope we can arrive at a commercial solution." It's an olive branch. It's an opening shot to start a discussion that we had hoped would result in a settlement, but sadly has not happened. And finally, by way of emphasis, we say that negotiations always have to start somewhere. And the start of a negotiation process, the opening shot, must be just as privileged as much as the rest of the negotiation, because otherwise it would undermine the public policy of the without prejudice doctrine, which protects parties who are speaking fully and frankly, even in their opening shot. Those are my submissions.
Thank you very much. Any questions at all? You okay? Mr. Dimitriadis.
Thank you, Mr. Chairman. Of course, the owners oppose the charter's application because the 4th of February email does not fall within the scope of the without prejudice rule. Before I move on to our submissions, if I could very briefly respond to my learned friend's submissions. Of course, my learned friend aptly identified that the without prejudice label only reflects the charter's intention, but is not conclusive as to whether the prejudice applies, the without prejudice privilege applies. Secondly, my learned friend has admitted in his submissions that the email in question cross-refers to earlier correspondence, and he is referring to the 3rd of February communications, which we understand is common ground between the parties, that those communications occurred on an open basis. And therefore, there is no reason to depart from that. So the owner's position is based on 2 core submissions. The first is that on the date of the email, there was no dispute between owners and charterers regarding their respective rights and obligations under the charter. It follows that there was nothing to be settled. The second submission is that in the 4th of February email, the charterers make no genuine attempt to compromise, they provide no offer to settle, and they do not advance any purported negotiation. Mere threats are not covered by without prejudice privilege. Moving to the first of those submissions, it is the owner's case that there was no dispute to be settled. I'm grateful to my learned friend for summarizing the legal test, which is common ground between the parties. In particular, if we could go to page 12 of the bundle, I would draw the tribunal's attention to the final sentence in subparagraph B, where in setting out the test, Mrs. Justice Joanna Smith states, and I quote, "It is essential to this public policy justification that there is a dispute." If the tribunal could now turn to page 9 of the bundle, and this is where the relevant email is. From the second sentence of that email, it is clear that charters accept that the owners are entitled to hire at the charter rate. As such, on the date of the email, there is no real dispute between the parties regarding their respective rights and obligations under the charter. This essential element is absent in respect of this email. This brings me to my second submission, which is summarized in the owner's skeleton at paragraphs 9 and 10. The owners say that even if there was a dispute, in circumstances where the parties' rights and obligations were common ground, the charterers made no genuine attempt to negotiate with the owners. That is evident from the terms of the email itself. And if we could go back to page 9 of the bundle, turning to that email, the second sentence of the email provides no basis for the application of the without prejudice rule. It simply declares that the charterers, and I quote, are just not able to pay higher at the charter rate. The third sentence of that email includes a thinly veiled threat that the parties, and I'm quoting, both know that the consequences will not be pretty. The reference to an alleged commercial solution is essentially a smokescreen. The email itself offers no such solution. The tribunal should not allow the charterers to escape the consequences of their statements simply because they have paid lip service to the idea of a commercial solution without providing any substance to back that up. Given the content of the email, it cannot reasonably be characterized as advancing a negotiation genuinely aimed at settlement. And one can sense check that conclusion by considering whether any purported negotiation was advanced through this email. It's common ground that the communications before and after this email were conducted on an open basis. The charterers are only seeking to exclude this single email. On any view, taking the 4th of February email in context, it does not advance the purported negotiation beyond the position arrived at through the open communications on the 3rd of February. And my learned friend has essentially admitted that in his submissions. Based on this, it cannot be said that the email was genuinely aimed at settlement, and therefore that it should not be covered. And therefore, we say it should not be covered by without prejudice privilege. For the reasons I've given, we would request that the tribunal dismiss the charter's application and that the email remains in evidence.
Do you say there's anything we should attach to the label without prejudice, or it doesn't affect your conclusions? Would it matter whether it was or was not at the top of the email?
Mr. Chairman, we say that it reflects the charter's intention to put the email in on a without prejudice basis, but it is not conclusive as to the outcome that the tribunal can or cannot reach.
Ziam, would you like to reply?
Yes, please, Mr. Chairman. I will be brief and indeed I hope only to take one point, and it is this. Mr. Dimitriadis has referred to Ms. Bridges' email as a mere threat or a thinly veiled threat, and it will come as no surprise to the tribunal that we take issue with this and we disagree. The words speak for themselves. I hope we can arrive at a commercial solution. Now, I've already addressed the tribunal earlier that we say it was an opening shot. So it doesn't matter that no concrete proposal was attached to this email. It was an attempt to open a without prejudice negotiation at which further concrete proposals might later on be discussed. And even if negotiations are forthright, frank, or even hard-nosed at times, it doesn't change the fact that they are negotiations rather than threats. That's not a threat, that's just business. Those are my submissions.
Anything to add? Any questions?
We can take it here, can't
Yeah, we'll have a word. Thank you very much indeed, both of you. We'll just have a word here. We were thinking of walking inside the room, but that looks to be fraught with difficulty. So we'll stay where we are and just have a whisper together. Thank you all very much for waiting. I hope you can all hear me clearly and loudly. Thank you very much for your excellent submissions. The tribunal has conferred and we have reached a unanimous decision, which is that the respondent's application to exclude the email of 4th February from Ms. Bridge to Mr. Ford fails. We admit the email into evidence. Now, strictly speaking, I might not need to say more, but in deference to the excellence of the submissions, I will. First of all, we acknowledge, as of course we must, the public policy, which is to encourage litigants to settle rather than litigate or arbitrate. Secondly, if you're going to settle something, then as counsel have agreed, you settle a dispute. And thirdly, if you're trying to settle a dispute, you often have negotiations to do so. Our view is that there was no real dispute here. There was no claim started which people were trying to settle by offering and counter-offering. There was a request by the charterers to renegotiate an existing contract, and the owners had initially said, well, we'll think about it, but there was no ongoing negotiation. So we do not believe that this email comes close to the necessary test of privilege. We completely understand, without having heard any witness evidence on the point yet, that the sender of the email thought it prudent to head it without prejudice, no doubt in a hope that it would be kept private and that it wouldn't commit people to a final position. But as counsel for the owners said, that does not, or does not in this case, affect our objective view. So we reject the application and the email will be included in the body of the evidence which we will look at. And my colleagues have quite rightly asked me to say one further thing to all of you, which is that our decision on this email, on including it into the evidence, in no way indicates any view that any of us has at the moment on the question, the main question before us, which is whether or not the charterers were in repudiation. That's something we haven't even considered yet. It is simply that this evidence will go in. I hope that's all clear. And thank you very much for your submissions.
Ladies and gentlemen, that concludes the opening submissions and obviously the application. We're now moving into the stage of evidence. We have two factual witnesses. One would often have expert evidence as well. It can sometimes happen that a witness is giving evidence and then there's a break for tea, or even a break overnight, or worse, a break over the weekend. And if that were to happen, which is not going to happen on this case, the chair of the tribunal would typically turn to the witness and remind them that there is a rule of evidence that during the break, they're not permitted to discuss the case or their evidence with anyone. As I say, that's not going to be the case in this instance, but it is a very important piece of evidential rules that we have. I'm going to pass you now back to the chair.
We'll now come to the witness evidence. Mr. Kenny, as claimants, would you like to call your evidence?
Members of the tribunal, I'm going to call my first and only witness, Mr. Ford.
Thank you. Mr. Ford, would you like to do a quick sound check, as we musicians say, just to make sure we can all hear you well?
Indeed. Thank you. Can you hear me well? Thank you.
Mr. Ford, thank you very much for coming to give evidence to the tribunal today. We're very grateful to you. In London arbitration, we do not require witnesses to swear an oath on any religious tome, but we do ask you to confirm that you will tell the truth throughout your evidence. Will you confirm that?
I do confirm that.
Thank you very much.
Mr. Ford, can I just ask you to look in the bundle in front of you at page 5?
Yes, I have it here.
And is that your witness statement?
Yes, it is.
And looking over the page, do you see your faint signature at the bottom of that statement?
Yes, I do.
And are you happy for this statement to be your evidence in this arbitration?
Yes, I am.
Mr. Ford, I've got no further questions for you. Mr. Bovenseek will have some questions.
Good afternoon, Mr. Ford. I understand that you've been in the industry for many years and you've worked your way up to a senior position at Fairway.
That is correct.
And in that role, I would assume that you send and receive many emails and have many phone calls every day.
Yes, I do.
And presumably before you negotiated the charter with Duxton, you had lots of past experience of charter negotiations.
Yes, that's correct.
So it would be fair to say you were very familiar with tough negotiating tactics on both sides.
Yes, I am.
Now, I understand from your statement that you'd heard on the rumour mill back in January this year that another ship chartered by Duxton had been arrested by bunker suppliers.
I did hear that, yes.
But you didn't know if the arrest was due to an inability by Duxton to pay the bunker suppliers.
That is true.
You also knew that Duxton operated a number of time-chartered ships.
Yes,
But it would also be right to say that you didn't know the details relating to Duxton's other chartered ships, such as their rates of hire, or even whether Duxton was seeking to renegotiate the rates of hire under those charter parties.
I did not. That is correct.
It's also fair to say from your point of view that a number of the hire payments had not been made on time in the past, and that by February this year, you were fed up with Duxton.
That is true.
And as head of the bulk department at Fairway, and having negotiated the fixture with Duxton, it would be fair to say that you felt a lot of responsibility internally at Fairway in relation to Duxton's performance.
Oh, yes.
And in fact, you were rather nervous that Duxton might not be able to pay hire in the future.
That is true.
So would you also agree that you had in mind that if charterers did default in paying hire in the future, it would be a lot messier from your point of view to terminate the charter after the vessel had loaded another cargo and was on another voyage?
Yes, that was one of my concerns.
So, Mr. Ford, overall, it would be fair to say that it would have suited you to have a good reason to terminate the charter before the vessel loaded her next cargo at Constanza.
Yes.
Ms. Ford, if I can just move on to the 5th of February telephone call with Miss Bridge, which you refer to in your witness statement. When you told her you would not agree to any higher discount on that call, it's right that Miss Bridge spoke in terms of Duxton's future ability to perform, but she never suggested Duxton didn't wish to perform if they were financially able to.
I don't recall her saying that. That's true.
So you don't say that Miss Bridge told you Duxton would choose not to pay hire, even if they were financially able to pay hire.
And that's correct.
When you told Miss Bridge that the owners wouldn't accept an agreed reduction in the hire rate, Miss Bridge told you she was unsure if Duxton would be able to carry on performing. That's right?
Yes, that is right, and that was one of my concerns.
So if I understand correctly, Miss Ford, Miss Bridge didn't say to you that Duxton would definitely not be able to perform the charter, just she was unsure about that.
That's true.
Miss Bridge also told you during that call that Duxton had run the numbers, but they hadn't been able to make them work.
Yes, she did.
It's quite possible that based on that statement from Miss Duxton, you made the assumption that Duxton wouldn't be able to make the numbers work in the future either.
That was my concern.
But in fairness, you'd accept that that's what you were assuming. It was not something that Miss Bridge actually said to you.
She did not say it.
And she didn't say that it was impossible for the numbers to work better in the future.
She did not say that.
As I understand it, you didn't discuss the possibility of the circumstances or the numbers for Duxton changing in the future.
We did not discuss that particular point, no.
And she didn't give you any of the actual numbers that she was talking about that they'd looked at internally at Duxton.
Save the request for 40% reduction, no. What was unclear, if I may just add, what was unclear to me at that stage, and one of my main worries, was whether she was asking for a 40% reduction for the forthcoming voyage, or perhaps for the remaining 3 years, which caused me considerably more concern.
But if I follow correctly, that was something you were unsure about and not something that Miss Bridge herself explained to you.
That's true.
And that's not something you specifically questioned her about.
I did not.
So it's quite possible that she was only seeking a 40% reduction in relation to the immediate following payment.
Maybe, but I was concerned about the future since we had already had 1 out of 4 years, and therefore, obviously, that meant 3 years left to run.
But Miss Bridge never told you that for the future, anything to the effect that Duxton would become insolvent, or she was certain that Duxton would become insolvent.
She did not use that word. That's correct.
And whilst you had worries about what Duxton's financial future would look like over the coming 3 years or so of the Charter Party, Miss Bridge didn't actually give you any details of Duxton's finances.
She did not.
When she referred to Duxton having financial difficulties, therefore, you didn't have any elaboration on that.
No, she did not elaborate.
You didn't therefore know details such as whether Duxton had any loans or they might be able to borrow more money.
I did not know that.
And you didn't have any details of Duxton's cash flow position either.
That's true.
So would you agree that at most you were told in early February that Duxton were in serious financial difficulty, but you were not told it was impossible for Duxton to be able to get out of that difficulty?
I did not know that it was impossible. I did rely on my own and my team's feelings about this going forward for the next approximately 3 years. And I also relied on information that I'd had from shipbroking and ship owning colleagues in Singapore, where Duxton are based. And the rumor, as you called it, the rumor mill, was turning quite quickly.
But just to be clear, Mr. Ford, what you therefore had in your mind was not what Miss Bridge was saying to you, but information you'd obtained from external sources, which you would characterize as market rumor.
This is true.
And you were not actually given information by Miss Bridge in order to be able to say anything about whether or not Duxton's financial position would improve in the future.
I did not know that for a fact. That's true.
Just finally, Mr. Ford, in your email in which you purported to accept Duxton's repudiation on the 6th of February, as I understand it, you were trying to sum up the gist of what you were saying there, Miss Bridge told you, as going forward, Duxton will not be able to pay hire in full. But based on your evidence today, would you agree that that's almost right? But a fairer summary would be that Miss Bridge essentially told you that going forward, there was some grave doubt or risk or possibility that Duxton would not be able to pay hire in full.
The words that she used in the conversation with me on the third, beg your pardon, on the 5th, after her email about which we can now talk, thanks to the tribunal's ruling, gave me serious concern for worry. She did not use the specific words that you have just posed to me, but she did give me enough to make me and frankly my team concerned, as I said earlier. And that was the reason why we decided the way that we did.
So you were concerned about the possibility of Duxton defaulting in the future, but you can't say that those were that she said in terms to you that Duxton would definitely default in the future.
She did not use that particular phraseology, no, but we were minded to make a decision sooner rather than later, particularly because the vessel, our vessel, was about to embark on a 6 weeks voyage, and it's much more difficult, as I mentioned earlier, to remove ourselves with a cargo already on board, particularly a cargo bound for that discharge country, where there are often delays, and we were just not sure whether she might be able to perform. That was our main concern.
Thank you, Mr. Ford. I don't have any further questions for you, but my learned friend or the tribunal may do.
Thank you.
No re-examination.
Thank you very much.
Questions?
Mr. Kenny, this is probably a question for you rather than for Mr. Ford. Can I just check, we've talked about information from the market. None of that's in front of us, is it?
No, madam.
Thank you.
Mr. Ford, I have one question, if I may. Paragraph 2 of your written statement, you say that Duxton were always paying hire late and we were fed up with it. Had you done anything about previous late payments?
We had complained to her, and I certainly mentioned that in the earlier phone call on the 3rd, and repeated it with my concern in my phone call with her on the 5th. She could not gainsay that because it was a fact, and she knew she had paid late on the previous few occasions. Plus, the rumor mill gave me and my team further cause for concern.
But no notices as such were sent?
That is true.
Understood. Thank you.
Mr. Ford, thank you very much for coming. Just help me with one point, if you don't mind. You had a conversation with Miss Bridge on the Monday of that week.
Yes,
She sent you an email on the Tuesday.
yes,
You had a discussion on the Wednesday.
yes,
The hire was due to be received by you into your bank account on the Wednesday.
yes,
It wasn't, but it was received by you on the Thursday.
yes,
That's right.
yes, that's correct.
You terminated the charter on the Thursday evening. I'm reading the word evening from your statement.
Yes,
So you knew that that the money was in your account before you terminated.
that month's worth was in, yes.
So my question is, did the payment that you received on the Thursday play into your decision in any way to terminate that evening? Did it affect your thinking? If so, how?
It did not affect the longer term thinking, since we had another approximately 3 years to go. We were, of course, grateful for that particular payment, one month in advance, as usual, albeit it was yet again late, playing into the concern that we had already had and that Miss Bridge had already conceded was her usual way of paying late. And we had, as I mentioned in my, excuse me, in my witness statement, we were feeling nervous and we were frankly fed up with these constant late payments in an awkward market with somebody who was, by her own admission, in difficulties. And we frankly felt nervous. That's why we did what we did.
Thank you very much. Does council have any questions arising from our questions? Not at all. Mr. Ford, thank you very much for coming to give evidence.
Thank
You're
you.
welcome to stay and
Thank
you're
you.
free to go.
Thank you.
Thank you very much.
Thank you indeed.
Mr. Bovensiepen, would you like to call your witness?
Thank you, Mr. Chairman. Yes, I would like to call Miss Bridge to give evidence.
Ms. Bridge, welcome to the tribunal. Thank you to the arbitration. Thank you very much for coming along to give evidence today. As you've heard, we don't require witnesses to swear an oath, but we do ask you to confirm you'll tell the truth through your evidence. Would you do that for us?
I do.
Thank you very much.
Ms. Bridge, can I just ask you to turn up your witness statement in the bundle at page 7? Please, could you confirm that that's your witness statement?
It is.
If you turn over the page, you will see faintly a signature above the date 30th of June 2025. Is that your signature?
Yes, it is.
Thank you. My learned friend may have some questions for you.
Ms. Bridge, can I start by asking you about the financial difficulties that Duxton encountered in 2024? You say there was a depressed bulk market. Am I right to think, therefore, that this charter was loss-making through 2024?
Well, the hire rate was not great. I think the real problem was the depressed bulk market, because there are other ways that charterers can make money rather than the higher you pay. It was the conglomeration of different events and cash flow difficulties, which is why we were paying higher late.
But am I right to think that those cash flow difficulties were because you weren't earning enough to pay the hire on this charter?
We were experiencing difficulties in making hire payments on time, but we did make them. We were never more than a few days late. It's always, time chartering operation. You've got bunkers going out, and in the beginning of 25, just before all of this, we had a problem with the bunker supplier. It's a conglomeration.
That may be so, but the reason why you were unable to pay it on time was because you were not earning enough from the ship in order to pay your hire commitment.
That's not really how it works. I look at, yes, the hire rate was higher than the market, but it's what I can get out of the ship, how much I can utilize her, what I can get for cargo, where I can get cheaper bunkers. Can I do slow steaming? Do I need to go through ICA? It's more than just the hire rate, but yes, the hire rate was higher than the market.
In all events, the non-payment or your failure to pay on time was involuntary. You just simply didn't have the means to pay on time, did you?
It was difficult to meet payments on time. A few times we were having to pay a month at a time, and it was on a couple of occasions, and we were never more than a few days late, and we didn't receive any notices or anything like that from owners.
Okay, let me then think about the situation with you in February of this year. You accept, I think, that you were under lots of pressure by February of this year. What had gone wrong in the early part of this year that was giving rise to that pressure?
Well, what had changed at that time, or what made it particularly difficult, was having received off-spec bunkers that we then rejected. You've paid for them, you still got to find other bunkers, and all this happened just before we were going to make this monthly hire payment. At the same time, because of the dispute, the bunker supplier arrested the vessel as well. So that's another cash flow challenge. So yes, they were difficult times, which is exactly why I wanted to approach the owner.
And the market remained depressed?
We were still over the market rate, yes.
And the figure of 40% that you proposed as a discount, that was the figure that you needed in order to right the ship financially?
In relation to the market price, I'm not sure that it was 40%. The reason for starting at 40% was to have a discussion and open it. And I was expecting Mr. Ford to counter with something. And if I needed 20%, I wouldn't start at 20%. So 40% was really by way of opening to basically have that discussion that I wanted to. I was looking, was there a way that we could cut outgoings at that particular time? And she was the most expensive tonnage we had at that time. And it was a long-term charter party, so it becomes more of a collaborative experience for both owners and charterers.
Do you accept that without a substantial discount to the hire, you simply would not have been able to pay the hire you'd agreed to pay under this charter?
We would have had difficulties that month, which is why I asked. We did actually pay the hire. The expectation was that we would be able to utilise our tonnage and get more cargoes in a different way. Yes, we had serious financial difficulties, but there was no expectation that we were going to go. My expectation wasn't that we were going to go under. We just needed to try and get the level of hire reduced. We had a 3-year time charter, or 3 years, sorry, still to go. I wasn't going to lose that vessel in the market. We'd be dead in the water as time charterers. So I was very careful
You'd fixed the ship for a voyage to Pakistan, right?
Sorry?
You had fixed this ship for a voyage to Pakistan, am I
Yes.
right?
Yes.
And you were losing money on that voyage.
Yes.
You were getting less for the ship than you were having to pay in hire.
Right, but I was looking at where the ship would end up in Pakistan, that I might have some more options open to me because the market nearer Singapore was better than in the Med. So I was also looking at the rotation.
Irrespective of what the future was, the immediate future was further losses for the duration of this voyage.
Well, for that month of hire, yes, for that 1 month, but the voyage would have probably taken a month. What I was looking for was to cut my outgoing cost and to have a discussion with Mr. Ford about achieving a better hire rate, yes.
Can I ask you about your email of the 4th of February? You say there, to page 9 of the
I don't have the
bundle.
I don't have it in front of me. Oh. Thank you, Geoffrey. Mr. Ford.
You say there, as things stand, we are just not able to pay higher at the charter rate. You don't suggest in your email that there was any reason why that was going to change.
Well, I said it without prejudice, which I was hoping, I'd already called him the day before because obviously I wanted to start a negotiation and you normally do that informally on a telephone. He said he was going to discuss things internally. I hadn't heard anything back. The hire was becoming due. And as I've also wrote, I hope we can arrive at a commercial solution. That was my point. I wasn't saying we're not able to pay higher.
Well, that's exactly what you do imply. You say, I hope we can arrive at a commercial solution because we both know the consequences will not be pretty if we have to default.
Yeah, if we...
You're implying, aren't you, that if no agreement is made, you will default?
No, I was asking for a commercial solution so that we could have an ongoing charter. And because I wasn't getting anywhere with the phone call, and I wasn't hearing back from owners and I wasn't getting any kind of counter, I said, if we have to default.
Okay, let's think about the...
I didn't say we were going to default. I needed to hear something from Mr. Ford, so I had to write something.
Let me ask you about the conversation you have the next day on the 5th. Do you remember what time you received the call from Mr. Ford?
It was in the afternoon.
Do you remember where you were?
In the office.
And he started the call, didn't he, by saying, we're not going to offer you a discount? That's right?
Yes, he called to say that, yes, they couldn't help.
And what was your reaction? Were you disheartened, upset? How did you feel about that?
Yes, I was disheartened and upset. But he had called, and I was hoping that we could continue that conversation. And I said I wasn't sure how we could make the numbers work.
You needed to say something radical to make him change his position, didn't you?
Yes, I was hoping to. I was talking about the numbers and saying that I wasn't sure whether to be able to carry on performing, but I didn't say I wouldn't perform. I would not have said I'm not going to perform. Oh, sorry, Mr. Ford, that means we're not going to perform. And we paid higher the next day because I realised that I wasn't getting anywhere.
Can I suggest to you that is exactly what you said to him? He said, we're not going to give you a discount. You said, in that case, we will not be able to perform.
I did not say that. I would not have said that. I said
You needed to say something to him that would make him stop and reconsider his position. And your strategy was to suggest you would not perform unless a discount was offered.
I did not say that. I said the numbers were difficult and I was not sure.
When you said to him, you've looked at the numbers, you told him you could not make it work. And that implied we are unable to continue to perform this charter without a substantial discount of the kind we're asking for.
I didn't say that, no.
Those are all the questions we want to ask. Thank you.
Thank you very much. Mr. Bovensey, would you have anything to reply?
Thank you for your evidence. I have two questions, if I may. One for background. You said in your oral evidence just now that this was the most expensive vessel you have. Is the size of your fleet, your chartered-in fleet, public knowledge? Can you disclose how many ships that you had that you were losing money on at that time?
I would never disclose how many ships I was losing money on. But there are market fixtures, reports. Our fleet varies at any one time. But one of the key components when I'm looking at costing and there are cash flow difficulties is which is the most expensive vessel and what are the terms. And the Pintail was the most expensive vessel we had and it was on long term. So if you're able to change that, whether in the short term or the long term, given the market, it would have been a huge advantage to us. Plus also in terms of market reputation that we're performing. That's why I say I would never say I wouldn't perform. We'd be dead in the water. The intention is always to perform and markets change. And a lot of it is about where the vessel ends up. It was better for us to be in Pakistan than East Med at that time, or what the prognosis was.
No, I understand that. Thank you. But were you going through the same exercise with other vessels, or were you only trying to renegotiate this one charter?
Well, it wasn't me on my own. We're several in chartering, but yeah, everyone was looking at what vessels we have. Can they be better used? There was we were in difficulties. You start looking at all the tonnage you have, and where you can get savings.
Thank you. That's very helpful.
I don't have any questions, Ms. Bridge. Thank you very much for coming and assisting the tribunal today. We're very grateful to you. You're welcome to stay. You're free to go. Is that the end of the witness evidence, gentlemen?
That's the witness evidence.
Ladies and gentlemen, that is the end of the witness evidence. I hope you're all enjoying it so far. I'm not going to put that to a vote just in case. Well, things seem to have gone quite smoothly, unlike the case of the master who was asked by opposing counsel, did you write your statement? And he said no. We're now going to do closing submissions. After closing submissions, the tribunal will leave because they're going to deliberate. We have no idea what they're going to say or find. And when they're out of the room, we're going to do our final vote. So please take note of the closing submissions because this time I'm really going to put you to task. Over to you, Mr. Chairman.
Thank you very much. Mr. Kenny.
Members of the tribunal, I'm going to start with two points of principle, which we invite you to keep in mind when considering the evidence. The first is that it is not the policy of the law to yoke a party to a contract and to a contracting party that has clearly expressed an intention not to perform. A charter of this kind is an enormous risk and a great cost to an owner. And to embark on a voyage to Pakistan with a cargo, with cargo interests, with the commitments that involves, it is a commitment which an owner should not be held to in circumstances that his counterparty is saying, we're not going to be able to pay the hire. And you must approach the evidence as to what exactly was said and what a reasonable ship owner would have understood from that, bearing in mind what is at stake for these owners and the commitment that you are holding them to or not holding them to, the risk that they're being invited to run with a party who is at the very least one who in the past has not performed, who at the very least by its own admission is saying we're in difficulties, we're in serious difficulties. The second point of principle is you must construe and understand or give a meaning to what Miss Bridge was saying in her emails and in her conversation with Mr. Ford. You must give it a meaning that a reasonable ship owner in the position of these owners would give it. This is not a text to be examined with a microscope. This is not a piece of statute that has to be read with an eye to what the statutory draftsman might have intended. This is a commercial communication between business people, and you're entitled to look at the gist of what she's saying and the message that she is intending to communicate. With those points in mind, we say that there are two communications in which these charterers have said in a way that to a businessman has an absolutely plain meaning, we are unable to perform this charter. The first of those you have in writing in the bundle. And you find it at page 9. It's the email of 4th February, which you've admitted. And there are two statements in that email, each of which is a clear statement of the charterer's inability to perform. The first is, as things stand, we are just not able to pay hire at the charter rate. Now, of course, I accept that that's caveated with as things stand. But read in context, there's nothing to suggest that anything is going to change. It's not pending the conclusion of some renegotiation of some other contract. It's not unless some specified eventuality comes about. It's simply, in the present circumstances, we're unable to pay, with no suggestion that any change to the present circumstances is either likely or even realistically probable. The second is what Mr. Dimitriadis discussed as a lightly veiled threat. It's not lightly veiled at all in reality. It's just a threat. She says, I hope we can arrive at a commercial solution, because we both know the consequences will not be pretty if we have to default. And the straightforward implication of that is no commercial solution, we will default. It's not a possibility. It's a clear suggestion and threat that unless there's a deal, there will be a default. The second communication on which we rely is the 5th February call. And of course, you have to start in your decision about this call with deciding what the words that Miss Bridge actually used were. And when you come to consider that and you think about the probabilities, I ask you to think back to the evidence that Miss Bridge gave in cross-examination. And I asked her, well, you'd put a proposal. They put a proposal backed up with the description of the severe situation they were in, which you've just read in the 4th February. And the answer she got from Mr. Ford was no dice, no deal. We're not prepared to make an offer. And I said to her, well, were you disheartened and upset? She said, yes, I was disheartened and upset. So what she said next really was the last throw of the dice. She had to say something at this point to reopen the negotiation. And you have to ask yourself whether it's probable that she would have thought it was enough just to say, well, there's a possibility we won't perform. That's what she said already. That's what she said on the best view for her in her email of the day before. She had to up the ante. She had to say something more. And what Mr. Ford says is she said, well, if you don't offer us a deal, we won't be able to perform. And we invite you to find that that is probable in the situation. We invite you to find that that is exactly what she would have thought it necessary to say in order to achieve what she wanted to achieve, which was a renegotiation. In those circumstances, on that basis, what we invite you to conclude is that Mr. Ford's evidence was correct, and that she did say, if you don't offer us a deal, we will not perform. So in summary, you have 2 communications, one on the 4th, one on the 5th, in each of which, by implication or by express words, the charterers are saying, we will not be able to perform unless you give us a reduction in hire. And that, as a matter of law, is a renunciation. We invite you in those circumstances to conclude that the charterers did, as the owners say, renounce this charter.
Mr. Kenny, I've got just one question, please. So we've determined that the without prejudice moniker, if I can put it that way, didn't attract privilege. However, can you help us with whether we should give any meaning or interpretation to the words?
As Mr. Dimitriadis said, clearly it was the intention of the writer was to put the word she was going to use beyond your view. Her intention was that she should be able to make a threat without that threat then being used against her in proceedings. But as you have now found that it is admissible, you must look at what the message that is covered by without prejudice was intended to communicate. And what it was intended to communicate was that unless there was a deal, a default will follow and the consequences will not be pretty. So the answer is, once you've disregarded the writer's intention that the message should not be used against her, you are entitled and required to consider what the words meant and what their effect was intended to be on the owners. And their effect was to communicate that these charters were unable to perform their obligations they had undertaken.
Thank you.
Mr. Kenny, one question from my side. We have the BIMCO, or the Charter Party had the BIMCO non-payment of hire clause in it. Now, I understand your case is more about future payments, but how do you reconcile that with that clause? Do we need to consider that clause in the context of your case on this preliminary issue, or can we ignore it?
No doubt, if payment had not been made when it was made on the 6th, then the owners would have exercised their rights under the BIMCO clause. But as it happened, payment was made on the 6th, and therefore the owners' right and remedy was to terminate on the basis of the threatened non-performance in the future, i.e. the following month and the month after that.
Thank you. I have no further questions.
I've got one question, if I may, about the full calendar here, that week of February. When on the owner's case should we look at whether the charterers were in renunciation? Should we look at it when they terminated on the evening of the 6th?
Yeah, the answer is you must decide, first of all, whether what they said on the 4th and the 5th amounted to a renunciation. And then secondly, whether the owners were entitled still to consider what they had said as a renunciation at the time that they purported to accept that renunciation on the 6th. Now, as it happened, there had been no further communications from the charterers which could have altered the effect of what they'd said on the 4th and 5th. But if there had been some other message, then obviously that was something you'd take into account in deciding whether, as at the 6th, when the renunciation was accepted, it remained the case that the charterers were in renunciation.
Are we entitled to, and in your submission, should we take into account, in whatever way we choose, but should we take into account that before the owners terminated, the charterers paid the higher instalment when we look at the overall position?
You're entitled to take into account anything that could reasonably be understood as a message from the charterers. And the question is whether you can attach any meaning to the fact of the payment of hire, and in particular whether you can attach any meaning to the payment of hire which in some way qualifies or detracts from what Miss Bridge said on the 5th. If payment of hire meant what I said yesterday about being unable to perform is in some way in doubt, then you might take that into account. But our submission would be, it means no such thing.
Thank you very much indeed. No further questions from the tribunal. Mr. Kenny, thank you very much. Mr. Bovensiepen, are you ready to go?
Thank you, sir, indeed. So in closing, I propose firstly to emphasise a few points about the test for enunciation, its application to the facts here generally, and then move on to address the findings that we invite you to make in respect of the 4th of February email, which the tribunal has ruled should be admitted into evidence. And finally, to address the evidence of the witnesses and the findings that we invite you to make in respect of the 5th of February telephone call between Mr. Ford and Ms. Bridge, which is so critical in this case. So turning firstly to the test for enunciation and its application to the facts here, in time-honoured fashion, I'm going to tell you that I have 5 propositions to advance, but in fact I will discover that I probably have about 6. Firstly, just a reminder that you're only concerned with the stringent test for enunciation, and this is not a case where owners say it was in fact impossible for the charterers to perform, only one where they say the charterers stated that they were unable to perform. So this is only a case about whether the charterers were clearly saying that in future they would fail to perform. It's not about any past failure. Second proposition is that the critical aspects of the test for enunciation to keep well in mind are those identified in paragraphs 3 and 4 of our skeleton. And in particular, I just want to highlight that even statements which give rise to grave doubt as to a party's ability or willingness to perform are not enough. It must be an unequivocal and unqualified statement. Thirdly, it's for the owners to clearly identify with specificity the statement they allege was made and which they rely on to prove renunciation. And you must consider what they say those were as compared both to Mr. Ford's statement and in particular, what Mr. Ford said during his oral evidence. Fourth, the meaning which such a statement would convey to the reasonable person in owner's position has to be considered against the background which we've set out at paragraph 5 in our skeleton. But in particular, whilst I would agree with Mr. Kenny that any statements from owner's perspective have to be understood commercially, the test is objectively what the reasonable person in owner's shoes would understand. So insofar as Mr. Ford himself personally, and this I would submit as the flavour of his evidence, was predisposed subjectively to receive any communications through a personal telescope of his concerns and worries, including based on rumours he'd heard, that is not a part of the objective test. And otherwise, the background is really that, in essence, charterers were only in the past guilty of some minor transgressions, but they had paid hire in full. And further, any slight payment delays were particularly minor from the perspective of the parties to this charter party, because they'd agreed, by virtue of the BIMCO clause, to a 72-hour margin before non-timely advance payment would justify cancellation. Fifthly, contrary to the assertion at the end of owner's skeleton, this isn't a case where the charterers were trying to lay all their cards on the table in an effort to get a reduction in hire. And in any event, that submission begs what those cards were. What's important is that Mr. Bridge and Mr. Ford were both experienced individuals and they knew the game well. Miss Bridge was not going to play this game naively by upping the ante, as my learned friend did. She was simply doing her best to renegotiate the higher rate consensually, if she could, in circumstances where charterers' financial future was uncertain and there were no guarantees one way or another. Sixthly, as I've touched on, unsubstantiated market rumour about charterers' financial position and vessel arrests in unknown circumstances are not matters which reasonable owners could take into account in evaluating charterers' future intentions. And Miss Bridge has given uncontroverted evidence that the explanation for the vessel arrest was a genuine quality dispute with the bunker suppliers. As it turns out, I have 7 propositions, so sticking with tradition. The 7th proposition is that finally you have to keep in mind that in itself, seeking to renegotiate a consensual hire reduction is only consistent with adhering to the contractual terms and not with evincing an intention to break them. Turning then...
Can I just interrupt you? I'm very sorry, but before you get on to how you apply those propositions to the case, if you don't mind. So if we're supposed to stand in the shoes of the reasonable person, or possibly the reasonable ship owner or ship operator receiving these messages from a charterers, can we or can't we take into account what the real recipient here, Mr. Ford, thought or said in evidence that he thought, or should we ignore that, put it to one side and decide what we would have thought as reasonable people reading Miss Bridges' message and hearing from her? Do we take into account Mr. Ford's evidence on what he thought?
I don't say, sir, that you can't take into account what Mr. Ford said he thought, but primarily because you're looking at the question objectively. It's ultimately for you to determine what the reasonable person would think. There are cases where it sometimes can be posed rhetorically. if that was what the actual recipient thought, then wouldn't the reasonable observer have thought the same thing? But I would invite you to consider very carefully on the facts of this case and on the basis of Mr. Ford's evidence, whether in fact the real position is that he had certain worries based not on what was said to him by Ms. Bridge or on objectively verifiable information, but in particular on the basis of market rumour. And it's that that should not taint your view of what the objective reader of the messages or the objective recipient of any communications on the telephone, my Bridge, would understand. So if I may, members of the tribunal, just turn now to the 4th of February email. And before taking you to it, I just ask you to bear in mind that regardless of what Ms. Bridge intended by the 4th of February email, what really matters is its actual content and how it would be reasonably understood, as we were just discussing. And regardless of whether Ms. Bridge thought it would be seen by a tribunal in a legal dispute or not, it's the actual text that matters. It's not, if this is really what my learned friend was submitting, what the author intended about how it should be understood. The test is from the perspective of the reasonable owner reading the message. So just looking at the message, which is at tab D of the bundle, I just want to quickly draw attention to 3 features of it. The first in line 2, which I'd emphasize, is the reference to as things stand, we are just not able to pay higher at the charter rate. That's expressing a current position and not a future position. It's not saying that into the future for all time, we won't be able to pay higher. Secondly, in the 3rd line, and something my learned junior has already touched on and emphasized, hoping to arrive at a commercial solution is the opposite of threatening non-performance. It's really seeking an agreed negotiated outcome. And finally, perhaps the icing on the cake, is that in the final line, the way it's put is if we have to default. If is a key qualification. It's only consistent with a possibility of future default. It's not saying that is a certainty. So if you read the message as a whole, we submit it's very far from containing an unqualified statement that charterers inevitably would default in the future. Finally then, as to the evidence of the witnesses, particularly in respect of the 5th of February telephone conversation, I once more first stress that the burden of proof is on owners. So insofar as you can't be sure what Ms. Bridge said, or there's any ambiguity about it, that is going to be fatal for owners' case. Second, because the charterers have not suggested that, because it's not suggested that charterers would in fact definitely be unable to pay higher in future, and underlining that point is the fact that charterers have remained solvent, it wouldn't even have been true for Ms. Bridge to have told Mr. Ford that charterers would definitely not pay full hire in the future, and that in itself makes it unlikely that she did so. What I understand was being suggested to Ms. Bridge was that she might have over-egged the pudding in order to persuade Mr. Ford to change his mind when he adopted the position that he wouldn't reduce the hire rate. But in my submission, that's really unrealistic. In her oral evidence, she convincingly rejected that suggestion. And her reaction was that she would not over-egg the pudding in that way by saying that charterers would be unable to perform. And indeed, she also said that it would be reputationally disastrous for the charterers if she was to go about saying that they were unable to perform. So it's just not something she would do. So we say it wouldn't make sense for her to have gone out on a limb by saying it was impossible that Duxton would be able to pay higher in future. It was enough for her to say to Mr. Ford, as she did truthfully, that charterers were in serious financial difficulty and there was a risk on the current numbers she wouldn't be able to carry on performing in the future. And her oral evidence was both convincing and consistent with that. As also just identified, the 4th of February email, which Ms. Bridge had sent the previous day, was actually equivocal on an objective reading. So again, it's unlikely that Ms. Bridge would have gone further in a telephone call than she would in an email which she'd marked WP. And further, inherently unlikely that Ms. Bridge would definitely state charterers would have been able to pay during a call when during that call there were no substantive details of charterers' financial position discussed, either in respect of this charter or in respect of the other tonnage that charterers had. By contrast, we submit that Mr. Ford's recollection is much more likely to be unreliable because for a number of reasons, as reflected in his oral evidence, he had every reason to wish to interpret Miss Bridge from his point of view as making a definite declaration of future non-performance because the responsibility that he personally felt for Duxton's performance, that he had been fed up and was nervous about Duxton's ability to pay higher in future, and that it would be much messier if the charter continued. So those were all reasons why, being concerned about the possibility of future non-performance, he was keen to make sure he could terminate forthwith. And in his oral evidence, it's fair to say, I think, that he largely accepted those points. In any event, looking at his oral evidence, it didn't really stand up to the statement that he made in his witness evidence, in his written witness evidence, about how categorical Miss Bridge had been. And it didn't stand up to, in my submission, my learned friend's suggestion that Miss Bridge had stated unequivocally to him that charterers would be unable to pay higher in the future. Lastly, although this is very much a fallback point and not one that I say we need, even if Miss Bridge had said unequivocally during the 5th of February call words to the effect that charterers would be unable to pay higher in future, by the time that owners purported to terminate, and I understand it to be agreed that that's the relevant time to consider the test as at 6th of February, we say that that statement was rendered unequivocal, was qualified by the fact that hire was paid in full, essentially because, although that's not speaking, if it is hypothesized that a message has been received one day saying it's impossible for charterers to pay hire in full, but that's followed in short order by charterers paying hire in full, then at the very least there must be some doubt or ambiguity introduced into the understanding or the reasonable understanding of the statement made by the charterers preceding day, because their very next action has contradicted that information. So in summary, we say that prior to the 5th of February telephone call, charterers didn't evince an unequivocal intention not to perform, and it's inherently unlikely that Miss Bridge did so on the 5th of February call. At most, she conveyed there was a serious risk of future non-performance, and that was enough for her purposes in negotiating. By contrast, Mr. Ford was clearly itching to pull the plug, and it's wishful thinking on his part that Miss Bridge went any further than to say that there was a serious risk of non-performance by charterers, and ultimately he didn't support the suggestion that Miss Bridge had gone as far as to say that charterers would be able to perform in future in his oral evidence. On the right test, casting grave doubt on the charterer's ability or willingness to perform is not enough for the owners to get home on renunciation, and we therefore respectfully invite the tribunal to determine the preliminary issue by finding on the facts that the charterers did not repudiate or renounce the charter. Unless I can assist you further, that was all I was proposing to say in my closing.
Thank you very much. Thank you very much, Mr. Bovensiepen. But Mr. Kenny, would you like to reply at all?
I just very briefly say this, that you were told two things about the 4th February email. The first was that the reference to a commercial solution is the opposite of threat. But when the words that follow commercial solution are because we both know that the consequences will not be pretty, you're dealing with a threat in the most naked form. The second is the words if we have to default suggests there's some doubt about it. But the if is the consequence of there not being a solution. In both, on both points, what Mr. Bovensiepen is offering you is a very nice and scholarly rereading of a message which carries a clear commercial message.
Thank you very much. I just, if I may, have one rather sort of side-on question for us before we consider everything. The agreed facts we've been given, paragraphs 11 and 12, suggest to me anyway that the market was going down or went down. Paragraph 12 says the owners relet the vessel for a year at a lower rate. And paragraph 11 said the charterers got another ship in to perform the charter voyage. So I guess they got a spot ship. But as I understand it, neither side is saying that the market has a direct influence on the question we have to answer. It's whether or not the charterers evinced an intention, which was renunciatory.
The fall in the market is the background to what the parties were saying to each other, and what may be probable or improbable will depend in part upon what the market was doing.
The future market movements, which were unknown as at the relevant time that you have to consider the question on the 6th of February, should not be taken into account. The only thing of relevance that arises from the future is because you know, in fact, that the charterers were able to remain solvent. In my submission, you can take that into account when you consider what it is that Ms. Bridge is likely to have told Mr. Ford about the dire straits or not that charterers were in, or the extent of their financial difficulty.
Thank you very much. I think that completes the closing submissions. And the tribunal will now, in due course, go and deliberate and come back with our decision.
Thank you all very much. The tribunal are going to leave the room, and we are going to have our second vote. I'm hoping it will come up on the screen again for the onliners. The question. Is that right, Margareta? Will the question come back up on the screen for the onliners? Thank you. So we've had the submissions, we've heard the evidence, and we are going to put it to a second vote. I'm going to keep the question very simple. Did the charterers repudiate? I'm going to ask for a show of hands, please, in the room, obviously not online. For those of you in the room who think the charterers did repudiate, please put up your hands now. 1, 2, 3, 4. I've got 4. Okay, and you won't be surprised to know what the next question is. Please, can you put up your hand in the room if you think the charterers did not repudiate? Do you mind if I don't count them? I'm going to say 96. So 96 of you say that the owners jumped the gun. Is this the online quote or vote? Oh, it's still going. You want to end? Where is it? Oh, it's still moving.
We can end it if you like.
Okay, 1 second. Let me just get my head around it.
So this was when the question was asked
First
first,
time.
and this is the question asked second time.
So it's not in absolute numbers.
99% answered. The first one.
So
and
so
only-
what's 57% are saying?
Yes.
Thank you. Thank you. I'm going to announce the winners, so to speak. We honestly have no idea what the tribunal are going to find. So this is really just between us and the people online. And what's bizarre is that the room has voted overwhelmingly one way, and those online are nowhere near as over. And in fact, they have voted the other way, but only by a small margin. So I don't know if that's a representation of, I don't know, picking up body language and vibes in the room. I just don't know.
Personal charms of Daniel Bowens, even, I think.
Well, so look, let me just give you the figures. On the first vote, in total, 176 of you said that the charterers did not repudiate, so the owners jumped the gun. And 24 said that the charterers did. And for some reason on the second vote, I don't have outright figures, but I got percentages for those online. Those online, 57% said that, oh, I'm sorry, I got it wrong the other way around. 57% said the charterers did not repudiate. Sorry, so they are with you. I'm so sorry, I got it the wrong way around. So by and large, overwhelmingly, the owners jumped the gun. That seems to be the upshot of the voting. I hope those online have enjoyed it as much as we seem to have enjoyed it in the room. We are going to have time for questions. There was one that I'm aware of that came up online. No, there's more than one now. I can see that there are 5 entries in the Q&A box, but I can't see what they all are. Margaretta, do you think our IT chap can come and help? Ladies and gentlemen, it seems the tribunal are back. That was very quick. It seems the jury has made a decision.
You still voting?
No, we finished. Thank you very much for showing me the questions online. Ladies and gentlemen, I'm now going to pass back to the chair of the tribunal, who I believe is going to render the award on an extemporary basis. If I put it down though, I won't be able to get it back up. Has it gone? Yeah. Okay, sorry, thank you.
Well, thank you both. Thanks to both parties for their excellent submissions. And thanks to both witnesses, Mr. Ford and Ms. Bridge, for taking the trouble. What's that? Thanks to both parties for their excellent submission, and thanks to the witnesses for coming here today and giving evidence to the tribunal. We're very grateful to you all. We're giving a very fast ruling, which, as I say, will be available in written form, which we'll sign and hopefully get paid for. But meanwhile, these are our immediate conclusions. If the parties jointly request us to flesh them out a bit, then we will, because we're moving very quickly. But I know the parties are anxious to get our decision on the case. This is a unanimous decision by the three of us, Ms. Houghton, Mr. Goss, and me. And it is a decision on the preliminary issue of whether the charters of the Pintail were in repudiation by way of renunciation in February 2025 of their contractual obligations. In effect, as we understand it, the parties agree that the question requires us to decide whether the charterers clearly and unambiguously demonstrated to the owners that they couldn't or wouldn't perform their future obligations. It's good enough for the owners if either the charterer said we can't do it or we won't do it. And it can be by words, by conduct, in writing, orally, both. But it has to be clear and it has to be unambiguous on the cases. And as we understand unambiguous, it means no room in our minds for doubt. Neither side relied on the BIMCO clause, although it was in the bundle, and that's a clause which allows the owner in this charter the explicit contractual right of triggering a withdrawal and therefore a termination of the charter if an instalment of hire isn't paid on time. That wasn't done. Instead, the owners, rely on a renunciatory position by the charterers. To answer that question, we've had a brief discussion on the submissions, the contemporary evidence, and the oral testimony, as well as the witness statements, which were put to us. And I should say right at the beginning that we thought that both witnesses, Mr. Ford and Ms. Bridge, were excellent witnesses. They were honest, they were thorough, they answered the questions as carefully and truthfully as they could, and they more than fulfilled their obligation to assist the tribunal. So we thank them both. And the decision we're about to make in no way reflects any shortcomings in their evidence. I hope their companies will read that statement in the award. They're still in a job. The owners terminated on the evening of Thursday, the 6th of February, and in our view, that's the time to take a snapshot of what the position was. The position by that time is that there'd been a conversation on the Monday, an email on the Tuesday, another conversation on the Wednesday. Hire was due on the Wednesday. It wasn't paid. It was paid on Thursday, and the owners terminated on the Thursday. Taking everything into account, and to give you our ruling first, then our reasons, so that you don't sit around for too long. Taking everything into account, we have reached the conclusion that the charterers were not in repudiation, and that, to put it colloquially, and without criticizing them at all, the owners therefore jumped the gun because they were not legally justified in terminating the charter party on the Thursday evening. We reach that conclusion for the following main reasons. First of all, we don't attribute critical importance to the Monday discussion. That was Miss Bridge prodding to see what gave, and Mr. Ford quite understandably said he'll go away and think about it. So nothing was cemented then. We were not, in the end, on a very difficult question, persuaded that the Tuesday email, at least taken by itself, was evidence of renunciation. It was said that as matters stand, they couldn't pay, and that if they had to default, then it wouldn't be good. It was, in our view, just short of saying we will not perform, we are defaulting, we're walking away. The without prejudice moniker to us had some business significance because it created, in our view, the overall impression that this was a negotiation to see whether there was some give somewhere. And overall, we didn't think that email was quite enough for the owners. The next question was whether the Wednesday telephone conversation firmed things up or whether it crossed the line for the owners in terms of renunciation. In terms of us being the reasonable, objective people standing in Mr. Ford's shoes, we have to reach a conclusion, we think, first on what was said before we interpret how we would have read it. And on the evidence we heard today, reading it with the statements, what was said was short of the charter saying we will either choose not to perform or being unable not to perform. Mr. Ford said with great candor that Miss Bridge said that she was unsure whether they would be able to carry on. And he said it was unclear whether or not she was saying they couldn't carry on for one voyage or for the 3 years. So we didn't think it was quite saying we couldn't perform and not quite clear that it was for the 3 years. We completely understood Mr. Ford's business concern that with 2.5 years of what seemed to be a charter above market rate, he and, as he put it, his team were not comfortable, and that they picked up possibly quite accurate rumours, we don't know, on the broking mill. But we have to look at whether objectively the charterers were in renunciation at that time. And although he said he had, quote, serious concern for worry, we don't think it was quite there. And we were further fortified in that conclusion by the fact that the charterers paid the money on the Thursday. We thought that was quite significant. They may have been trying it out and seeing how far they could get. They may have had money. They may have diverted funds for the purpose, for that reason at the time, about to load a profitable cargo. But we thought it was more difficult still for the owners to say they were not going to perform their contractual obligations when a day earlier they just performed their contractual obligations, albeit in terms of one payment. No criticism or significance is attached to the owner's decision not to terminate under the BIMCO clause that day. By that time, they'd received the money anyway, and the BIMCO clause effectively means they have to wait for 24 hours. And no doubt they wanted to see what was going on. But our conclusion on all the evidence and submissions reached in our discretion is that the charterers were not in repudiation of their obligations, and that is our decision and will be enshrined in our award. Anything to add? Thank you both very much. Neither of you has asked for costs, I don't think. So we don't make any order. We reserve the costs. You'll no doubt want to consider where you go from here with in terms of any other damages or other claims. And we will issue our award as soon as it's ready, and hope that your respective clients will pay for what in writing will largely repeat what we've said orally. So thank you all very much for a very intriguing afternoon, and thanks again to the witnesses. Thank you.
I will. Thank you all. Thank you. The tribunal might be interested to know that the huge majority in the room agrees with your conclusion. Online, it was very, very close. It was almost 50-50. I thought was quite interesting. We do have some questions, but do you mind if we keep an eye on the time? Because we did say 6 o'clock we would stop, and there are drinks to be had, and it is very close to 6. I don't know if there are any questions in the room. I know there are some online. Let me have a look at them. Found them. Anything in the room? I'm going to take one in the room and then one online. And I hope that's fair.
Thank you very much. My name is Michael Abiba from Lagos, Nigeria, Bloomfield Law Practice. Well, even though I fall within the minority, in the vote, I still want to thank the tribunal for the decision. Now, I observed in the course of the hearing that the witnesses were both in the room. In a live situation, what will play out? The other witness who's not a party, will that person be in the room or will have to be excused? I'd just like to get a quick guidance on that. Thank you.
Thank you very much, and welcome. Thank you very much for coming along. it was certainly a close call. So you're quite right, quite justified in taking the other view. We sometimes get requests, formal requests by the parties before a hearing that one side's witness or witnesses should be excluded from the room while the other side is giving evidence. For myself, I'm not in favor of it. I believe it's important that the witnesses hear what each other has to say, because their evidence is usually flip sides of the same coin. Thank you.
I think
Thank you.
Maybe just to add, we would generally ask the council or the parties if either party objects to that and get a view from them, submissions from them before we make a decision. But otherwise, yeah, I agree.
I'm going to take just one question online. There seems to be a lot of concern about the WP email. The question I'm going to take, sorry, I need to put this down a minute. I can't get it. The very first question that came in was something along the lines of, because the WP email had not been countered, the expression used was negated, but I think the individual meant countered. So it still stood. Does that mean it was still effective as against the owners? Does that make sense? So I can't see. If the owners, if the ship owners didn't respond negatively by denying the without prejudice validity, did the email still stand? I'm struggling to formulate the question, but there does seem to have been a lot of noise about this WP email.
Is the question? Yeah. Sorry.
Oh, thank you. Thank you, Robert.
So the owners wanted to say it was actually not without prejudice, it was open. They should have replied. And by silence, they're agreeing that it is without prejudice.
Oh, that's very cunning.
I think that's what they meant.
The answer is that's the sort of thing that charters would say. You're absolutely right to say, and you and Anonymous of Online, I think I may have come across as Anonymous of Online before, are right to say that one of the bases on which without prejudice privilege can be established is agreement between the parties to treat their correspondences without prejudice. And there is a great attraction to saying, if I've sent a message without prejudice and my counterparty has not written back to say, I refuse to treat this as without prejudice, that tacitly the negotiation goes on without prejudice. I can only say that amongst the excellent points that Mr. Yen took, that wasn't one of them.
Thank you, Robert. I'm going to wrap up. I do have a few thank yous, so please bear with me. We cannot underestimate the amount of time and thought that went into preparing this moot from council. Each and every one of you, we are particularly impressed with the problem that you came up with. It gave us a huge amount to think about and talk about, and we are extremely grateful for the time and effort that you put into it, so thank you. Thank you to our witnesses who stayed in character the entire time and performed brilliantly. So thank you for your time. The whole idea for this moot was actually Ben's, Ben Goss. You too put a huge amount of thought and time into this. I think it's been a great success, but then I would say that, wouldn't I? Thank you very much indeed for thinking it. The IDRC always gets our thanks. Behind the scenes, they do so much work, the tech, the room, you name it. And we are very grateful. There you are, David. Thank you very much indeed. Margaretta, standing here, I don't think it's an exaggeration to say that if we didn't have you, the LMAA would absolutely grind to a halt. So big thank you from all of us for the work you do. Finally, do we thank the tribunal? Yes, okay. Thank you very much indeed, all three of you. We're finished. Please come and have drinks with us. Thank you.